What should I expect at mediation in the Waterbury Judicial District for my car accident case? If you've been injured in a car accident in Waterbury, Connecticut, mediation may be the path that resolves your case without ever stepping foot inside a courtroom. Mediation in the Waterbury Judicial District is a structured, court-connected settlement process where both sides work with a neutral mediator to resolve your car accident claim before trial. Unlike a trial, where a judge or jury issues a binding decision you cannot control, mediation gives both parties the power to reach a voluntary agreement on their own terms. The mediator does not decide who is right or wrong. They guide discussion, identify common ground, and help the parties explore realistic settlement numbers through private caucuses and joint sessions. Connecticut adopted the Uniform Mediation Act, effective October 1, 2025, which establishes confidentiality and privilege rules designed to protect statements made during the mediation process. In the Waterbury Judicial District, civil cases are often handled through Connecticut Superior Court at 300 Grand Street, and mediation may occur through court-sponsored ADR programs, private mediation, or another court-approved settlement process. Court-connected mediations are frequently conducted by judge trial referees or retired judges who can offer both sides a candid and experienced view of how a Waterbury jury might value a particular claim. Mediation is typically scheduled after the pleadings close, and discovery is substantially complete, ensuring that both parties can negotiate from a fully informed position rather than settling before the true scope of injuries is understood. The process generally moves through several predictable stages: referral to ADR, confidential pre-session submissions, a joint opening session, private caucuses with the mediator, and finally, either a signed settlement or a return to the court docket. Preparation is the single most important factor in achieving a successful mediation outcome, and you should bring police reports, complete medical records, all bills, lost wage documentation, photographs, and your insurance declarations pages to the session. Understanding your underinsured motorist coverage is critically important when the at-fault driver carries only Connecticut's minimum 25/50/25 liability policy, which may fall well short of covering serious injuries. Connecticut law, under General Statute Section 38A336, prohibits the stacking of multiple UIM limits from separate policies or vehicles, meaning you are legally limited to a single applicable policy's limits even if you pay premiums on multiple vehicles. A skilled attorney who understands Connecticut's anti-stacking rule and knows how to document the full value of your damages can make a profound difference in the outcome of your mediation session. At DeFronzo Petroskey, PC, lawyer Dan Petroskey represents injured victims throughout the Waterbury Judicial District and surrounding Connecticut communities, working closely with clients to evaluate damages and prepare for mediation from a position of strength. When your recovery is on the line, you deserve a law firm that understands how to navigate the Waterbury Judicial District's mediation process and fight for every dollar you may be entitled to collect. Call DeFronzo Petroskey, PC, at 203-756-7408, located at 255 Bank Street #2B, Waterbury, Connecticut 06702, United States, to schedule your consultation with an attorney today.